My name's Daniel Thorpe, and I'm one of the two most junior tenants in Chambers, having just joined following the completion of my pupillage. As Jonathan rightly said, I'll be talking today to you about interim applications. Now, that is an incredibly broad topic to squeeze into 20 minutes or so. So I am going to be talking about applications to set aside default judgment, but before that, applications for summary judgment too. Hopefully you can see my email address on the slides there, and that's potentially important because, again, for those of you who didn't hear, I do have to slip off after my section today because I have a hearing that begins just after 12 o'clock. So if anything I say prompts any questions from you, the audience, I'd encourage you to just drop me an email and I'll be happy to help where I can. Hopefully you can see a Q&A function at the bottom of your screens. If you submit any questions via that, we will be able to answer them if we can. If not, again, please do email me. So without further ado, summary judgments. The way I'm going to approach this talk today is based on what I've called case studies. And I suppose these aren't so much case studies that require pre-reading or anything like that, but hopefully just scenarios which you as junior practitioners will be able to relate to. So first of all, imagine on any given day of the week, your client is slapped with a summary judgment application. Your partner comes along to you and says, "We've just received this, please can you deal with it? Please can you fix it?" Again, hopefully that is something you can relate to. So there are three questions really, which I think arise from that. What is the application? What do I do next? And why should I do that? So first of all, what is it? Again, hopefully this is something that you are all at least a little bit familiar with, but just by way of refresher, the applicable framework for summary judgment applications found in Rule 24 of the CPR, and particularly Rule 24.2. There are two criteria which need to be satisfied in order for a summary judgment to be granted. And these are cumulative requirements. It's important to remember that both of them need to be satisfied. The first is that the claimant has no real prospect of success on the claim or issue, or alternatively that the defendant has no real prospect of successfully defending the claim, depending on who, of course, is applying for summary judgment. And the second is that there is no other compelling reason why the claim or the case or issue, I beg your pardon, should be disposed of at trial. Now, what do those two things mean? As I've summarised on the slide there, the ED&F case is long-standing authority that no real prospect of success, well, no real prospect is to be defined as something which is realistic as opposed to fanciful. And something with a real prospect of success is something which is more than merely arguable. Now, in terms of the no other compelling reason criterion, it's very difficult to lay down specific guidance on what this means, and the courts generally embark on a case-by-case analysis. And we're going to look at some contenders or some reasons which people have tried to suggest are compelling later on in the talk. Now, there's a note there at the bottom of the slide which talks about burden of proof. And this is important. Again, this comes from the ED&F case at the top of the screen. But it's for the applicant in the summary judgment application to establish that the respondent has no real prospect of success by adducing some credible evidence. Now, if they do that, it is for the respondent then to prove a real prospect of success or to demonstrate a compelling reason. Now, this is not a particularly high burden, but it's important to note that burden of proof does shift. Now, again, in the final line of the slide, I've adopted the non-technical terminology of a more senior member of Chambers who I was discussing this with the other day. And his view was that as a respondent to a summary judgment application, it's your task to muddy the waters a little bit. If we can muddy the waters in terms of the applicant's evidence, or in terms of why, in terms of why this has to go to trial, we are going to hopefully be successful. So how do we achieve, or how do we go about that muddying process and trying to disrupt the applicant's application? And I've grouped this into three, what I've called options there on the slide. The first things first, we ought to consider the formalities of the application. Second is we ought to consider whether or not amending our statement of case is attractive or possible. And the third is essentially taking the application on in terms of the evidence and issues that are currently live in the proceedings. So I'm going to deal with the first of those first, the formal requirements of an application. Now, as with all interim applications, the general provisions of CPR Part 23 apply by default to the extent that the rules in Part 24 don't displace them. I'm not going to go through those requirements in detail because they're fairly straightforwardly set out, but just to mention that Part 24 does contain some specific provisions relevant to summary judgment applications, and those, for example, deal with who may apply and when. So the claimant may not apply before the acknowledgement of service or the defendant's defence is filed unless they seek permission of the court first. The defendant may apply from any time after the proceedings are issued, and those both found in Rule 24.4. There are also provisions about notice for the hearing. The respondent must be given at least 14 days notice to enable it to get its evidence in order. And that evidence, the rules on that evidence are found in Rule 24.5. The key one from a respondent's perspective is that he, she, or it has until 7 days before the hearing to file any evidence. Now, hopefully compliance with those procedural requirements is stating the obvious, but it is surprising how often they go overlooked. And sometimes, in my experience, an applicant sails fairly closely to the wind in terms of following the letter of the rules on the basis that the court sometimes does sort of waive or allow the applicant to get away with it. However, last year, Lord Justice Floyd in the Court of Appeal offered a stern warning against those who would adopt that strategy, and referring in particular to the requirements of the practice direction on summary judgments, said that they are of critical importance to ensure a fair hearing of the application. Now here, the application notice, or indeed the evidence, had failed to state that the applicant believes that the respondent has no real prospects of success. Seems like a fairly formulaic requirement, but this prevents, in the word of Lord Justice Floyd, a claimant making an application and claiming the case to be more straightforward than what he actually knows it to be. And on the facts of that case, this was one of the reasons why the appeal against the summary judgment was allowed. So the take-home point, the first thing we need to consider that we learned from the Price case is that it's really important to make sure that the applicant has its house in order. Now, the second point is perhaps slightly more complex, and that is the prospect of amending your statement of case. Now, the objective here is to, as I've put there, is to cure the alleged defect. And what I mean by that is summary judgment applications almost always allege that something is wrong with the pleading in question, whether that's the claim form, particulars of claim, or the defence. What the applicant is essentially saying is that what you've done so far does not disclose a position with a real prospect of success. Now, it may be that you take a look at your statement of case and think, well, they perhaps have a point there. So what do you do next? Now, the rules on amendments of pleadings and statements of case are contained in Part 17 of the CPR, and again, don't really have the time to go into a detailed consideration of those provisions. but simply note here some of the key things we need to think about. So sometimes, as will often be the case in these summary judgment applications, if the statement of case has been served, the court's permission is generally required. You'll need to think about limitation, whether or not limitation period is expired. But also you need to think about how promptly you're making that application. And I've referred to a recent case there in the High Court for any Sex Pistols fans in the audience. How you can quite be a fan of that sort of thing, I'm not quite sure. But that involved a certain Johnny Rotten, who attempted to amend his statement of case partway through the trial. Needless to say, that was not a successful application for that and other reasons. But if you are going to amend, formally amend, that is, get that application in as soon as you can. And I've referred to another case there back into the realms of summary judgment with Folgender Holdings, which was a relatively recent case decided by Chief Master Marsh. And his view was clear that if you are thinking about amending your statement of case, you must do that. You must make that formal application before the hearing, the summary judgment hearing. Now, that position is subject to change now. And this emanates from a decision of the Court of Appeal in Bomani and Sattar, which is referenced there on the slide. But in particular, the decision of Master Clark in Schill Properties and Bunch usefully sets out what is now the position in respect of potential amendments to statements of case and summary judgment applications. And it's also a useful decision because it emphasises, I beg your pardon, quite what the court is looking at when we are considering these summary judgment applications. So in that case, it was all about contract for the sale of land. Mrs. Bunch, the seller, had filed a draft defence. The Schill Properties, the buyer, had claimed for specific performance. Mrs. Bunch had filed a defence raising various issues. And shortly before the summary judgment application, she filed as evidence a draft defence, but stopped short of making a formal application to amend. Now, this evidence came within the time limits prescribed by Part 24 of the Rules and the Practice Direction. So in other words, the evidence that she submitted was in time and was before the court properly. But the question was whether she could rely on what she'd put in that draft defence for the basis of her response to a summary judgment application. And Master Clark, applying Bomani, said that she could. And the key part of the judgment is excerpted on the slide there. And the assessment that the judge undertakes under Part 24 is one of assessing the evidence and not the pleadings. So the court is not really interested primarily as to what your pleadings say. It is the court's job to look at the evidence in a sort of big picture way. And the final thing you need to consider when looking at responding to a summary judgment application is something which I've described as considering the evidence and the issues as broad and vague as that sounds, but hopefully this will provide you with some more information. Now, the first thing to do is consider what evidence is before the court at the moment and what we know about the applicant's case. Now, the first thing I've put there is you might consider requesting further information by making a Part 18 request. Now, again, I don't have time to go into a detailed consideration of Part 18 rules, but this is potentially a useful strategy because it will put you on the front foot, perhaps. Look at the applicant's statements of case and their witness evidence. How well is their case made out at the moment? Is there anything which is vague or which is poorly particularized? If so, you may wish to consider requesting further information from them. And that could have the effect of, they might consider agreeing to vacate the hearing for the time being, for staying the application, just to give you a bit more time to iron out any issues that you need to iron out prior to that hearing. And the second thing, which is related, is the actual physical evidence which is available at the time of the summary judgment application. Do you think there are any factual issues which require further disclosure or perhaps cross-examination at trial? In the Shield Properties case, the judgment of Master Clark, which was on the previous slide at paragraph 50, he simply said that if disclosure is necessary for the court to fairly determine the claim, then it is unsuitable for summary judgment. And that must be right if we're thinking about compelling reasons for going to trial. If things are not sufficiently clear at the moment to enable the court to make a summary determination, it's only right that disclosure should happen, and then the parties can take stock. And this is consistent with a decision of Lord Justice Voss, again from the Court of Appeal, in the Alpha Rock Solicitors case. He said that the court should exercise caution at the summary judgment stage. And this is because of the draconian effect of handing down a summary judgment and the risk that at trial, I beg your pardon, events may appear less clear-cut than they do in an interlocutory stage. And another thing on this consideration of the evidence in the issues. Historically, it's been the case that the summary judgment judge would not easily entertain applications which necessitate detailed consideration of weighty legal principles or contain questions of construction. And recently, the tenor of the case law is that things are changing. So in the TFS Stores Limited case that is on the screen there, Chief Master Marsh again handed down a judgment which basically emphasised how the court is comfortable at the summary judgment stage, or can often be comfortable of resolving issues of well-established principle. So he said there are no compelling reasons why this claim should go to a full trial. The basis of the defence does not rely on any new principles of law, and the issues raised by the defendant are capable of being resolved by applying the well-established principles that govern the construction of contracts and the implication of terms. The context in which the claim is made does not entitle the defendant to contend that these principles are now part of a developing area of law. So that's all well and good. But as a respondent, what do we take from that? Well, I think the emphasis has to be that if your position is a simple one, and if you're relying on well-established principles of law that are settled and not rapidly developing, your ability to argue that this is a compelling reason for going to trial is that the issues are complicated. It won't be a very strong one. Now, the flip side is if you can demonstrate that the legal principles you're relying on are hotly contested, or that they have important factual significance. There's often cases talked about where, for example, industry-wide standard terms of a contract are at issue. If the court is being asked to construe those industry-wide terms at a summary stage, that is perhaps an indication that a full trial is necessary. However, if you are invoking developing areas of law or complex issues, and the evidence required is also necessarily complex, you are not guaranteed to make it to trial. And this is not a guaranteed case of a compelling reason why you should go there. And again, a stern warning was given by Mrs. Justice Cockerill in the Foglier case, which is on the screen there, again, a recent case of this year. The facts and the issues were complicated, and for current purposes, it suffices to say that the case involved issues of fraud, of knowing receipt, dishonest assistance, unjust enrichment, and had a pretty high value at €3.5 million. And Mrs. Justice Cockerill did start by saying, I bear very much in mind that it is highly unusual for claims of this sort to be decided summarily. However, she did grant summary judgment, and she said, taken together, issues which have not, in my judgment, adequately been explained by the respondent, provide a body of evidence which I consider does justify the preliminary conclusion that any innocent explanation is fanciful. So the take-home point here is that if the applicant has presented a case which is well set out, there is evidence to justify it, and you as the respondent simply cannot explain why or how you are hoping to successfully defend that at trial, just because there are issues of complex issues of law, there is evidence that may come forward, or there are potential issues of construction, that is not going to be enough. And so then we come to default judgment, and I'm conscious of the time, so apologies if I fly through this. Again, what I've called a case study. This is simply along the lines of the first case study, whereby you have been, a client has come to you perhaps quite late in the day and has produced a default judgment. What is it? What do you do? And why are you going to do it? And in my experience, this is often a case where a litigant in person has simply ignored correspondence from the court, correspondence from his opponents, to the effect that default judgment has been entered, and he, she, or it is in a bit of a sticky wicket. Now, again, the legal framework for setting aside default judgment is to be found in the CPR, and specifically in part 13, 13.2 and 13.3. Now, 13.2 sets out criteria for when the court must set aside a default judgment. And the emphasis there is on the must, the mandatory nature of the rules. Again, I'm not going to go through these in detail, but the essence of these provisions is where by some irregularity, the judgment has been entered against the defendant. And that is often because something has been missed. So for example, an acknowledgement of service or a defence has actually been filed in time, but for some reason, the court staff or somebody else has missed that and the judgment has been entered. The more tricky aspect of the rules is the discretionary grounds, and that's part 13.3. And there are essentially two-stage tests. The first stage is engaging the discretion of the court, and that is by showing that you have a real prospect of successfully defending the claim, or that there is some other good reason why the judgment should be set aside, or that you should be allowed to defend the claim. And in either of those cases, that application must be made promptly. And if that first stage is satisfied, if you engage the discretion of the court will then go on to assess its discretion according to the relief from sanctions, the well-known relief from sanctions test from Denton. In other words, that's all well and good. We appreciate you've fulfilled the 13.3 criteria, but why should we exercise our discretion in your favour? And there are similarities with the two tests, which is why I've sought to link them in this talk today. Both refer to a real prospect of success, and in the ED and F case that I referred to earlier, the judge set out quite simply what the main difference is, and that is in respect of the burden of proof. Like before, the test for the real prospect criterion for setting aside a default judgment refers to something which is more than merely arguable and not fanciful. So again, to rifle through these options, as I've called them in the remaining few minutes, the first is to consider whether or not there are any grounds upon which you can set aside or have the court mandatorily set aside the default judgment. And obviously this is the easiest way to do it. There is no assessment of the defendant's prospects of success. You could have a hopeless case on the merits. There's no requirement that the application, I beg your pardon, be made promptly, and there is no question of the court having to exercise its discretion because it simply doesn't have one. There was a recent case actually the Frontera Resources Corporation case at the bottom of the slide there, which did explore a situation which, at first blush at least, might fall between the mandatory and discretionary grounds for setting aside a default judgment. And that was where it was found that there was no valid service of the claim form. And the judge there said the default judgment must be set aside under 13.2, the mandatory grounds, because it was entered at a point in time where the acknowledgement of service had not expired. There was simply nothing to respond to from the defendant. The claim form had not been validly served and the clock had not started to tick. In that situation, the default judgment must be set aside. And that is to be contrasted with the common argument that many of us will have seen before, that the defendant comes to you and says, that's all well and good, but I have not actually received the claim form. I didn't know these proceedings were going ahead. That is why I didn't respond to it. What do I do now? And as I've put there, it's a common argument. And I think all judges who deal with these applications are used to seeing this. And it can be a persuasive reason, a persuasive good reason, depending on the nature of the allegations. For example, in Berezovsky there were serious allegations of witness intimidation, and the court was not comfortable allowing those to pass under a default judgment without taking it to trial. But more interestingly, in the Fatih and Mohammed case, again of this year, His Honour Judge Pelling QC was faced with a defendant who had moved to Turkey, but was served his last known business address in the UK. Now, for obvious reasons, he hadn't received notice of the proceedings, but the judge said, whilst this was prima facie a good reason, under the relief from sanctions test in Denton, the defendant needed to explain in more detail why the breach had occurred, why hadn't he responded to the claim. And the judge said, because this was a business address, we can expect the defendant to have made arrangements to receive post, and he could not adequately explain why he had not done that. So it's important that we go beyond saying that we haven't received the claim form or we didn't have notice of the proceedings. We need to say why. And lastly, I'm going to end here. We can take on the application and look at the substance of what our defence is actually going to be. And having done a few of these applications in the past, my key take-home point here is that it's important to put in a draft defence as quickly as possible, preferably in advance of the hearing. And in the Ali Balogan case, again of this year, which I've referred to on the slide there, the judge recognised that there is no formal requirement to file a draft defence, but a draft defence is potentially important because it essentially makes the court's job easier. And the absence, and essentially what the judge did here is drew maybe not something as strong as an adverse inference, but read into the fact that no defence had been prepared to expose holes in the defendant's defence. From experience, especially in the county court, there are district judges out there who will demand that a defence is filed in advance of the hearing of the set-aside default judgment application, and will not be best pleased if they do not have one before them by the time the application is heard. And apologies for rushing through those last few slides, but that brings to an end my talk on interim applications. As discussed, I am going to have to shoot off. I don't think there are any questions which I can assist with now, but should any questions be thrown up by what I've said, please do not hesitate to get in touch with me via email. And so without further ado, I think I will hand over to Jonathan, who's going to talk about preparing witness evidence, and in particular, amongst other things, the new practice direction. So Jonathan.
Thank you, Dan. Slide straight in. So I'm not going to be focusing just on witness evidence itself in this talk. I'm going to be addressing also the other things you ought to be considering at around the same time as completing your witness statements and submitting them, the witness statement deadline. I'm going to run through the recent practice direction in the business and property courts. I'm going to do that fairly briefly because there's a wealth of recent information about that. I'm going to address some of the other rules about witness statements, especially ones that I think are frequently overlooked. Briefly mention witness summaries, what they are, how to do them, a bit about hearsay, and then I'm going to wrap up with a short mention of the need to challenge documents formally if you're going to say that they're not genuine, they're forgeries or something like that. And lastly, I should be saying I'm all going to be assuming that we're talking about relatively ordinary civil proceedings in this jurisdiction. There are various other rules which apply where you're trying to obtain witness statement for use overseas. The practice direction in business and property courts, I imagine many of the people listening to this will have dealt with this by now, because it came in partway through last year. It applies by default in many kinds of proceedings, although there are quite wide exceptions. As I said, those include a lot of the insolvency and companies court work, notably probate proceedings. I'm not quite sure why. I think probate proceedings is an area where the practice direction might well be extended to. And also Part 64 proceedings, which deal with the affairs of trusts and estates. Those are all excluded from the scope of the practice direction for now. Those of you who have encountered the practice direction, especially those of you who have actually had to produce a witness statement following it, but anyone who's read it will see that it's not a small reform. It's quite demanding in the approach it requires to be taken. The objectives, very broadly speaking, are to remedy a perceived, and I think rightly perceived, tendency in witness statements that they are very often not just the document of the witness, but have a very strong flavour of the lawyer's input as well. So it's always been the case that the rules have said that the witness statement should be written in the witness's own words, but we'll all have seen many witness statements that clearly aren't. They're written in lawyerly language with sophisticated sentence structure, and then one can see the witness go into the witness box and it's totally different. So the new practice direction is trying to get back to that more purist view that the witness statement is standing in for oral examination in chief. So things that the witness could properly say if, and would say, if asked questions in the courtroom by their own counsel, the counsel for that side, as part of their examination in chief. And relatedly, that means not arguing the case, not making comments on things that were outside the witness's knowledge at the time, or comments on things that actually the witness has no recollection of, but someone's trawled through the documents that have been disclosed, found some things that look like they're useful, and got the witness to make some remarks about them. And how is this achieved? Well, as I say, the idea of the process is that rather than a carefully constructed document with input from multiple people into its wording, it should be produced as directly as possible from things that the witness themselves says, and minimizing the witness using documents as an aid. It should be the witness trying to give their evidence of what they actually recall. That's broadly speaking the objective of the practice direction. Remains to be seen how well it will work. But in theory, if you follow it assiduously, you are likely to end up with something quite different to the characteristic style of witness statements that used to prevail. There's a lot more to say about the detailed practice direction, which I won't be saying today. There is a statement of best practice, which is an appendix to the practice direction. That's not an optional extra. You really do need to read that if you're going to be doing a witness statement to which this practice direction applies. This slide just contains a few of my personal observations on how this works. I think so far I've only done one case where we really had to think about this. I went to trial earlier this year, and that depended very heavily on disputed facts, not all of which appeared in the document. So something we put a great deal of effort into. It is very time consuming and resource intensive following the process in the practice direction. So you do need to get started on it fairly early. If you're leaving it to the days leading up to the witness statement deadline, you are bound to have a big problem. My first observation is that I think the best way to do this, at least for witnesses who are going to have a lot to address, is to schedule an interview where you can go through everything at once, almost recreating oral examination in chief. So more open questions, at least to begin with. You are allowed to follow up with more specific queries. I draw the analogy with oral examination in chief. A colleague of mine who knows about these things points out it's quite a lot like the deposition process in the United States, which you might have seen on television. It is allowable to follow up on further occasions, to address anything that wasn't addressed first time, and for the witness to make revisions, clarify, change what they said if in fact it's mistaken. But you want to be doing that, you want to be keeping that under control. And certainly you don't want to get lured into the trap of inviting the witness to alter their witness statement in ways that seem like they would be favourable, because you shouldn't be doing that, and also because you might well, although superficially making the evidence look more helpful, actually make it weaker, more susceptible to challenge and cross-examination. If this is going to go well, this interview, you really do need to devote the time to preparing for this interview. It's obviously less important an exercise with witnesses who only have peripheral comments to say. In that case, the rules still apply with the same rigour, but in practice, it's going to involve a lot less work than with the witnesses who are central to the case. Second point is the most annoying thing about the practice direction in my experience is the requirement to include a list of documents that the witnesses refer to in preparing the evidence. This is really quite difficult where the witness in question is a party witness, so they're actually, the case is about them, because those witnesses are bound to have gone through the disclosure process. They'll have certainly reviewed the statements of case, instructions will have been taken from them, all sorts of documents are likely to have been picked up and shown to the witness and discussed with the witness in the past, all perfectly legitimately. There's a bit of a debate about how comprehensive this list of documents has to be. My own view, although I'm aware that there's a different school of thought, is that this is about the process of making the witness statement. So I don't think it's necessary to list all the documents in the case that the witness has seen ever, or anything like that. It's the documents that the witness has referred to around the time of preparing the witness statement. It is very annoying to keep track of this, but you do need to do it, which is also a reason to not show the witness statement, the witness documents unnecessarily. That will make this task more difficult. But I don't want to totally discourage showing the witness documents. Most cases will have important documents in them that the witness will need to address. And it's certainly allowable to show the witness those documents, and most of the time will be necessary. Third observation is that the practice direction is explicitly aimed to cut out a lot of the content used to see, background, context that the witness doesn't know from their own perceptions but has worked out, arguing the case, that kind of thing. That wasn't all useless. It could be quite helpful to put things in context for the judge. The way we approached this, both sides were agreed on this, here, in the case I did earlier this year, was that you could agree to have another document which looks a bit like a witness statement, but isn't, and so these rules don't apply, specifically for the purpose of setting out the kind of information that is useful for the court, or hopefully useful, but is not, strictly speaking, proper material for a witness statement, if you're following this practice direction. This isn't a formal thing. This is something that we both thought would be, both counsel, that is, and solicitors, thought would be useful for the court. We agreed it, and the court could have said, no, I'm not reading your documents, but the court did find that a useful exercise. And I think often in cases, particularly cases where by the nature of it, the witnesses can't give a full picture between them, you might want to supplement that with a document of this kind. Because this isn't a formal thing, there's no particular rules about how you do this. My view is that if you are going to have such a document, it should be verified by a statement of truth, but in the same kind of way that a statement of case is verified by a statement of truth. So the party should read it through, and it should be true to the best of their knowledge and belief, but that doesn't mean that they necessarily actually have personal knowledge of all the contents. Last thing on this third point, if you are going to do this, you should really be doing it after any witness who's going to look at this document has done their own witness statement, because here, in the exercise of producing this separate document, you're doing lots of the things that practice direction specifically says you're not supposed to be doing as part of the process of creating a witness statement. So, so as not to contaminate the witness statement process, especially for them to do their witness part first, finish that document, and then, if the witness is the party, have them look at this contextual narrative document. Fourth point, it's still open to debate whether the practice direction is effective, whether it rewards parties who make proper efforts to follow it, or whether it will penalise them. But my personal view is that if you assiduously follow the practice direction, you are likely to end up with a witness statement that is a lot less polished and maybe less superficially strongly supportive of your case than if it had been produced with more lawyer input, less restricted to what the witness themselves would say. But the upside, and it's a very important upside, is that because it's more limited to what the witness themselves would say, it ought to be more resilient in cross-examination, which is of course absolutely critical, because one of the repeated problems with overly lawyered witness statements is that you get to court, and unless the witness is very sophisticated and has the intelligence and memory and has made the effort to really absorb the contents of their witness statement, they might not really know what it says, and it might say a lot of things that they don't actually know, and that can open up huge weaknesses for cross-examination, which might destroy the credibility altogether. So I think the following practice direction is likely to be more helpful to your case than trying to circumvent it. So I'm in favour of the introduction of this practice direction, but we'll see how it works out. Moving on, even before that practice direction, where that practice direction doesn't apply, there are other rules about contents of statements that are not always adhered to, but are important. Practice direction 32, particularly paragraph 18, specifies a number of things that witness statement should include. Some of them are not of particularly great significance most of the time, things like the witness's occupation, but are supposed to be included. Two things are particularly important and often overlooked. First, and this is a relatively new requirement, is that the witness statement should explain how it's been prepared And I see many witness statements, perhaps even the majority, don't do this. You're supposed to do it. You don't have to go into enormous detail. You're not required to waive privilege, but you should briefly describe how it's being prepared. And there's reference there to an interpreter. There are other rules as well which apply to translated statements or statements written in a language that the witness is not fluent in. I'm not going to address those right now, but certainly if you've got a witness who's not doing everything in English, you need to be alive to those concerns. Make sure that you familiarize yourself with everything that's supposed to be done where there's a degree of interpretation between languages, and then do it, because you can have awful problems if at trial your witness, having made a fluent, perhaps very sophisticated witness statement, obviously can't speak enough English to actually possibly have made it. That can be a very sticky situation. The second point, no less important, is that the witness statement's got to explain what points in it are made from the witness's own knowledge. So this is things about their own state of mind, or that they themselves actually perceived and remember, and distinguish those from things which they believe are true, but they have gleaned from elsewhere. So it's something that they've been told by someone else, or they've read it somewhere. And in the latter case, you've got to explain what the source is. And this is very often not complied with, and it leads to some rather shadowy evidence where the witness is saying things that they can't possibly know themselves, but they assert it as something that they understand, but without explaining on what basis. That does not make for strong evidence. It opens it up to cross-examination. It opens it up to just being rejected as not being of sufficient weight. So it is important to do that. I'm not going to take you through the various formatting rules. There are quite a lot, which are set out in the two practice directions. Practice direction 5A is about court documents generally. That includes witness statements. One subject that I think doesn't come up very often, but perhaps should more than it does, is you don't have to leave the other side's witness evidence unscathed up until trial. The other party might do all sorts of annoying things with their witness evidence, including reams of irrelevant material, and particularly annoying, in my experience, is the tendency of some parties to include allegations of quite serious wrongdoing that is irrelevant, but as a mudslinging exercise. The court does retain a power to control evidence and exclude issues from consideration in the proceedings at all. Obviously has to be exercised in accordance with the overriding objective. But if something is irrelevant and it would require disproportionate resources to actually deal with it, which is often the case with serious allegations of historic wrongdoing that aren't directly relevant, the court can rule against it and say, I'm not going to take into account those matters. And that means you don't need to cross-examine on them, for instance, or adduce contrary evidence. So that can cut down the evidence that's before the court. And you don't have to wait to trial until doing that. Then in the new practice direction, there are some specific powers that are additional to the court's general powers. And they apply where there's been non-compliance with the practice direction. And on the face of it, these sanctions are quite powerful. You can strike out all or part of the witness statement, probably only worth doing if there's significant parts, or there are parts that can be easily isolated that you want to get rid of, and that shouldn't be there. 2, requiring that the witness statement be redrafted. It's more likely to be appropriate where the witness statement is being produced not in accordance with the practice direction. It includes all the kinds of things it's not supposed to include, like arguing the case. Probably quite seriously annoying to be required to do that, because it means that much of the cost incurred in producing the first draft will be wasted. And so worth bearing in mind that in an appropriate case, you can invite the court to make that direction. And third is requiring the witness to give some or all of their evidence in chief orally, which is an interesting one. There's something to be said for that, because if the practice direction has not been followed and the witness statement has been produced in a different way, with the witness statement is one of these carefully crafted witness statements with heavy lawyer input, you can't really undo that, because that exercise will have been done in the recent past. And so the witness will have been affected by that exercise having occurred. So it will be very, very difficult, if not impossible, to do it properly. Redoing it might not fix the issues. And so there is this quite significant power to say that instead of being able to rely on a witness statement, you must give your evidence in chief orally, or part of it. And I would have thought that any party who's ordered to do that is going to have serious concerns about how that's going to go for them at trial, because now they can't be confident that there's going to be evidence before the court that actually establishes their case prima facie. It might be that they give evidence in chief orally and don't give the answers addressing what they need to address. So if such a direction is made, that's going to, I'd have thought in most cases, seriously worry the party who's on the receiving end. If you are going to ask the court to exercise these powers, there's nothing stopping you doing an application at any time, but the obvious occasion to do it is at the PTR. Witness summaries, I'm going to go through these quite quickly. Sometimes you can't get a witness statement for whatever reason. The witness can't cooperate or doesn't want to. And you nonetheless feel that you need to at least try and get evidence from them, perhaps because you're concerned that if you don't do it at trial, the other side will argue, why don't we have this evidence? An adverse inference should be drawn because it's absent. You need to apply for permission to do this as an alternative to witness statement, but the application doesn't need to be an elaborate one. It can be without notice and will usually not require a hearing. What it will need to do in practice is explain why you need permission, i.e. why you can't do a witness statement in the normal way. And in my view, it's really essential to have your draft witness summary ready so that the court can see exactly what you're asking permission to do. The content of the summary has to either set out the evidence which would be included in the witness statement if you know what it's going to be, or what you expect it's going to be. That will sometimes, but not always, be the case. Sometimes you won't be able to get from the witness at all any evidence. So you don't know what their answers to questions will be. And in that case, you've got to set out instead what questions you're proposed to ask. You don't need to set out absolutely everything when you're doing, because what this will lead to is oral examination in chief. You're not strictly limited to questions you put into your witness summary. You are allowed to elaborate and follow up, but you're supposed to sketch out what the examination in chief is going to be. Moving on, something that's not so much about witness statements, hearsay notices. But you have to do these at the same time as witness statements, which is why I've wrapped it into this talk. Hearsay evidence is actually a very wide category indeed. It's a statement not made in oral evidence, whether examination in chief, cross-examination or re-examination, but which is relied on as evidence of the things said. In civil proceedings, hearsay evidence is generally admissible. In criminal proceedings, it's more complex. There is a requirement to give notice if you're going to rely on hearsay evidence. The definition of hearsay evidence does actually catch all written witness statements that are going to be relied on at trial, or practically all. And in that case, there's no need for a separate notice, just serving the statement does it. Second point is, where you've got the witness statement, but you're not going to call them at trial. Again, you just need to serve the witness statement but well, not just that. You've also got to indicate that the witness is not going to be called and explain why. So the witness might have died after making the statement, or they might be doing a stint on the International Space Station or whatever, or they might be seriously ill or lost capacity. But you have got to give a reason. It should be a good one. And third is all other kinds of hearsay evidence. You then do have to do a notice, and it's got to identify what the evidence is, indicate it's going to be relied on as hearsay, and give the reason for not calling a witness to produce that evidence. There are some exceptions. I've set them out there. The one that I encounter most is, I suppose, well, all interim hearings. So solicitor witness statements in support of interim applications, that kind of thing. No need for that. And I think the practical one that I encounter most is probably probate proceedings. The obvious reason that deceased is no longer around. So they're not going to be able to give any oral evidence, and you don't need to give a notice to rely on statements made by them. You can just address it in any other way. Usually, you'll have witness statements from someone else quoting the deceased, which is fine. Or you might have documents written by the deceased. The requirement for a notice can be waived or excluded by agreement, and one of the ways that can happen is when agreeing the contents of the trial bundle. Anything that's agreed for inclusion is going to be deemed admissible as evidence of the contents, and usually in practice it's treated as being admissible generally, although strictly speaking I think the parties need to agree that. Once if you get a hearsay notice from the other side, there are two active things you can do. You can dispute, it should just be admitted as hearsay, and you can apply for them to be come and give oral evidence instead. You've got to do that within 14 days of the notice. There's another step in the rules, which is you can give notice of an intention to call evidence to attack credibility of the hearsay evidence instead. Again, 14 days applies to that. Was one of those active options. As a passive one, you can just leave it as it is and wait until the trial to say that this hearsay evidence has little or no weight. There are factors non-exhaustively set out in the Civil Evidence Act, Section 4. They're all fairly common sense things. About how reliable the evidence is, how has it been produced, was there any motive to give false evidence, that kind of thing. And lastly, and include this in this talk because again you have to do it at the same time as your witness statement deadline, and also because whether documents are accepted to be authentic or not is going to be very important at trial when you're cross-examining. The underlying principle is you're not supposed to take the other party by surprise. If you're going to be saying that this document says what it says, but actually it's been tampered with, or it's a complete forgery, you're not supposed to say that for the first time at trial. And the court can give you permission to do it late, but it might refuse permission, and also you might run into practical problems because you might not be able to get the original to investigate whether there has been any tampering. Important rule is that disclosed documents are deemed to be admitted to be authentic unless you take the active step of serving notice. And you've got to do that notice by the witness statement deadline in most cases, or because as we all know, people disclose documents late. If later, you've got 7 days from the time of disclosure. So that might even be within the trial if someone discloses documents on the first day. Which is a good reason not to disclose documents late if you needed another reason, because the other side might challenge their authenticity and you might not have a lot of time to react to that. Although there is this deemed admission, it's not an iron rule. The court does retain control over these kind of things. And one circumstance that you're likely to be all right, even though you've not done a notice, is if it's already sufficiently clear so that both parties are already proceeding on the assumption that the authenticity of a document is an issue. And that might be, for instance, if your statement of case says that something is not accepted to be a genuine document. There are a few cases on this. I'll explain one of them. Right, that takes me to the end of the things I was going to say. I see there are a number of questions, so I'll rattle through those. First question is understanding that generally practice directions like 57AC are responsive rather than proactive. And questioner asks, is it the case that a law firm has made a substantial hash of the witness statement process? If so, do I know exactly what happened? The answer to this is, yeah, not just on one occasion. There are loads of cases where judges are extremely critical of witness statements. The most embarrassing are where it becomes apparent that actually the witness didn't do the witness statement at all. The lawyer drafted it for them, and in some cases, just put the witness's signature on it without the witness actually seeing it. Less bad than that, the situations where the lawyer has again suggested all of what the evidence should be and just got the witness to agree, which is not how it's supposed to work. Yeah, you're supposed to take the instructions from the witness about what their evidence is and then put it into the form of a witness statement. But that doesn't always happen. So yes, if you search for cases where witness statements have gone horribly wrong, you'll not find any shortage of them. Second question, will you be releasing a copy of the slides? Yes, for both my talk and Dan's. And those should be emailed around afterwards. One question is the non-witness statement that I described. Sounds like a position statement for mediation. I suppose there is a certain similarity. A position statement for mediation will very often describe the background and the documents that are considered to be particularly relevant in a way that a witness wouldn't. Obviously, on the other hand, there are some differences. There are things you would say in a position statement for mediation that you wouldn't say in a document of this kind that you're going to be using at trial. But certainly the view both sides took in the case I did was that the document in question didn't have to be a neutral document. So it was putting documents in the favourable context. So I suppose in that respect, it is again a bit like a position statement for mediation, where you're trying to explain why you've got a good case. Next question, what if you do a statement for an application at an early stage? Then you create the non-witness statement document I've described for the purposes of the application. You don't need to do this for interim applications. The whole practice direction only applies for trial witness statements. And practically speaking, most interim applications, in my experience, are mainly supported by witness statements from solicitors, who are very unlikely to be giving evidence at trial anyway, so there's not going to be any contamination of anything they do later. Or they're witness statements from parties, but on matters that aren't actually relevant to the issues that are going to be at trial. So for instance, if you have an application for security for costs, you might have a party witness talking about their financial circumstances now, but that's not what the trial is going to be about, most likely. So again, you're not likely to have any contamination. This narrative statement, how would you file it and at what stage? Again, because this isn't something the rules specifically provide for, I think it's really for the parties to suggest something that they consider appropriate, subject to the oversight of the court. The obvious time would be either at the same time witness statements are produced or shortly afterwards. We did agree with the other side, the principle. It was the other side's suggestion, in fact, so we agreed to it. To what extent did you seek to agree the content? Not at all. We agreed that each side could produce their own document, which could be non-neutral and present the documents and the narrative in the way we want it to. I don't think so the question is, how did this interplay with the case memorandum or case summary, or the list of issues. I suppose I don't think we actually did a separate case summary in this case, but a case summary would be different because it would have to be neutral and agreed, and would also probably be much shorter. The list of issues, this was a relatively complex case, so we had a separate set of directions for us to liaise on a list of issues. So I think we did that before the narrative documents. So by the time we got round to producing the narrative documents, each of us, we knew what the issues in dispute were. Next question. Is an issue with giving evidence in chief orally that this is done some time after disclosure, and therefore after the witness may have seen a significant amount of documentation? That's not what I perceive to be the main problem, because not many witnesses giving evidence in chief orally are going to remember much of the disclosed documents. So they're unlikely to be affected by that, or at least not more affected than they were going to be anyway, because disclosure is practically always going to come before witness statements. So to the extent the witness is interested in looking at disclosure, whether they give evidence in writing or orally, they will have seen it. The main issue with giving evidence in chief orally is that witnesses are often not very good at it. They forget crucial bits of their case. So their counsel is asking them open questions, trying to invite them to say the things they need to say to establish their case. But they don't give the answers that are required. So that's the main reason why you don't want your own witnesses to be giving evidence in chief orally. It creates massive uncertainty. How well will they actually do it? Whereas if it's in the witness statement, and the witness statement is before the court, then it's there. You can be confident the evidence is before the court, and it's for the other side to challenge it in cross-examination. If the witness doesn't say it in oral examination in chief, the other side don't need to cross-examine because the evidence just doesn't exist. With regards to contentious probate matters, well, we don't have to actually follow all the requirements in the new practice direction. What approach would I recommend? I think it's a good idea to follow the spirit of the practice direction and really try and keep the witness statement focused as much as possible on things that the witness statement actually knows and remembers. But probably the bit of the practice direction I'd be most willing to discard is the need to set out exactly what documents the witness has been referred to. But I think trying to avoid commentary and argument and really focusing on what the witness remembers and getting it in the witness's own words is important in all cases. And I definitely recommend following the guidance in the new practice direction on those subjects. Last question is, how do you respond to a challenge on authenticity of a document? Well, I suppose that depends. You might accept that a document is not authentic. If you're going to accept it ever, probably best to do it sooner rather than later. But assuming that you're going to be saying the document is authentic, you don't need to do anything formally. If you're relying on the document as evidence, and as long as you've got it into evidence somehow, for example, as an exhibit to a witness statement, or you've done a hearsay notice, then what you need to do in substance is make sure that you're going to be able to prove its authenticity. So, for instance, where the document is a handwritten document or has a handwritten signature, you might want to seek a direction for expert evidence about that. Or with electronic documents, you're going to want to investigate the original electronic document, so the original email file, for instance, if it's an email, and possibly, again, get expert evidence to comment on whether that file does represent an email that was genuinely sent at the time it appears to have been sent, and in the same form, that it hasn't been altered. So you just need to have a think about how you're going to prove at trial that the document is authentic. Right, well, those are all the questions. Thank you very much for those. Unless there are any others, thank you all again for listening. I hope it's been somewhat useful. And yes, as I mentioned, we'll send out the slides later. Okay, thank you.